Welcome to Ask the Expert. I'm Robert Capper, head of the commercial team at Harrison Clark Rickaby's, and this morning I'm joined in conversation by Michael Stokes, head of our employment and business immigration team. Michael's going to talk to us about all things furlough. Michael, to start us today, would you like to talk to us about what you think of the latest developments in furlough?
Well, I think we're moving into the next phase as far as the government's concerned. They've conducted a fairly successful state-funded layoff system for the last few months. And although that was done in a rush by employers and by the government, that has largely worked in terms of delaying some very difficult decisions about redundancy or changes to contracts. So that has worked. What the government's now trying to do, just as a political matter, is get everyone ready, all the employers who've taken advantage of the furlough scheme so far, to move them towards becoming self-sufficient again. And they're doing that by essentially introducing a state-funded short-time working arrangement, gradually phased in over the next few months, creating a few markers over the next few months, like the 10th of June, which we'll come back to in a moment, I'm sure. And then arrangements changing gradually as the months go by until the system is withdrawn altogether on current information at the end of October.
Okay, thank you, Michael. So there's talk at the moment about an important date coming up and the 10th of June being a cut-off. What's the significance of that date?
The point about the 10th of June is that after the end of June, it won't be possible to furlough someone for the first time. So if an employer wants to furlough anyone from the 1st of July onwards, they, as an individual, have to have been furloughed for 21 days by that date. And the only way you can fit a 3-week minimum furlough under the current scheme in before the end of June is to furlough that person who has never been furloughed before on or before the 10th of June. And that's why that's such an important date. If you have an employee who hasn't been furloughed by then, the government won't let you furlough them moving forward from the 1st of July.
So if you're watching this webinar before the 10th of June, check your dates and check your employees. If not, sorry, the date has passed.
Yes, I think I had a query just yesterday, which was a very practical one, just on this point. That employer is thinking about furloughing employees for the very first time in all this. They're just realizing that they will need to into the autumn. And they have a continental shift system, so 4 days on, 4 days off, working 12-hour shifts. And so they were worried that the 21 days during which someone has to be furloughed in June to be eligible for furlough in July and beyond, whether that was somehow cut down by the fact that they wouldn't have to work for 4 days at a time during that shift system had they been at work. And fortunately, I was able to reassure them that that doesn't matter, that you just have to have 21 calendar days from the date you furlough someone before the end of June for that employee to be eligible for furlough in the future.
That's a helpful point there, Michael, very helpful, thank you. So lockdown is in the process of being lifted, albeit gradually and in steps, but there are still lots of lockdown rules in place. What's the implication of an employee breaching lockdown, and is there any disciplinary implications in particular?
Well, you can separate that into two. If we deal with the situation within employment, so if someone was to breach some sort of lockdown provision actually during their work for their employer, then their employer would, I think, be able to rely on that as an act of misconduct, even though it wouldn't be on anyone's list of types of misconduct in a disciplinary procedure at the moment. I think if you breached the rules at the moment and you knew what they were, then I think you'd be susceptible to a disciplinary process within your employer. That leads on to a slightly separate point, which is whether if someone breaches lockdown rules away from the workplace, effectively in their private life, and the employer finds out, to what extent can that be a disciplinary matter in the context of their employment? Because that's what I'm principally interested in. I I don't worry about someone's civil or criminal liability for doing that. I'm just thinking about what an employer would make of some Facebook posts, for example, showing one of their employees flouting lockdown rules, whether that employer could do anything about it. And I think that there's nothing in principle to stop an employer relying on that sort of misconduct away from the workplace as being something that would affect or could affect their employment, would certainly potentially affect their colleagues, their ability to work. It would be reckless behaviour that could affect the employer indirectly and could affect colleagues directly. So to give it a comparison, in the same way that someone having a punch-up in a pub on a Friday night in sight of a lot of work colleagues, even if it's not a work function, that's the sort of misconduct that I would look at if I were an employer, because it affects the relationship between the employer and the employee. I think that lockdown breaches, flagrant lockdown breaches, pictures of tremendously large barbecue gatherings, or people tightly huddled together, I think that could prompt disciplinary action just in an ordinary sort of way, and tribunals would understand that if an employer took that view.
Yeah, I think there's a follow-on question from that, Michael, which you talk about people gathering in huddles for barbecues. What protection can employers take in the event of employees breaching lockdown rules and then as a result having to find themselves in 14-day isolation, which of course then penalises the employer?
Yeah, I think that if an employer in the current situation makes it clear to employees that they don't just have responsibilities at work. So an employer will be making sure at the moment, every employer will be making sure that they've carried out a risk assessment so their workplace is as safe as it can be in their particular context. And that's happening everywhere, it should be happening everywhere. Employers can also, I think, make it clear to employees that general behaviour in line with the general understanding, the spirit of lockdown arrangements, is something that the employer will be monitoring, because if someone is putting their own health recklessly at risk, then that can rebound on the employer, of course. So just the one employee who is committing what I think of as being misconduct away from the workplace in that way, that's one thing. But putting the health and safety of other employees at risk, that's potentially a much bigger issue, and that's going to happen. That sort of suspicion that an employee has exposed themselves to risk and therefore exposes their colleagues to additional risk, that is going to come up in a number of cases. I think the point about this is from an employment lawyer's point of view, is that the employer has to have made it as clear as they can what will happen if something like that occurs, if an employee does something that either does cause a problem or could cause a problem, so that if an employer finds out, for example, about a large gathering that would be in breach of lockdown rules, and they can see it going on, and they decide that the employee has to be away from work, I don't think it's beyond the bounds of reasonableness for an employer in that situation to suspend the employee. The next question from the employer is, do I have to pay them during that suspension? And I think that there's always a danger when you don't pay an employee, when you haven't clearly agreed the circumstances in which you will not pay employees. So I think that that's another thing that a wise employer will introduce now, either as a change to a handbook or as a separate effectively announcement, try to make it happen as a contractual change, if it has to be a contractual change, that there are circumstances when people will be sent home potentially without pay if they have put themselves in that situation. But that's a risky strategy for an employer. They're much better to announce it, get agreement on that. Everyone should be pulling in the same direction at the moment, employees and employers. But you have to take care. You can't just punish someone in a new and exciting way because you think it is the just thing to do. I've had one example put to me already where a different firm of solicitors has just imposed that on their employees. And I don't know whether they did it carefully or did it as most solicitors might do, just introducing it because it's obviously the right thing to do. But that would be risky. If you just punish someone by sending them home without pay for 2 weeks, you're asking for a claim, you're asking for difficulty, and what if you're wrong as the employer? So I think that has to be approached with care, but I don't think it's an unreasonable punishment if it's introduced in a reasonable way.
So employers can take steps, can take practical steps, and there is an opportunity to do it on a wider scale, but at the end of the day, it's all down to individual circumstances and dealing with each of those appropriately. So
yeah, I think that the practical way forward in that particular case, I suppose, is that if you know that someone has acted in breach of lockdown guidelines, regulations, so effectively breaching the spirit and practice of the government guidance in a way that's going to put other employees at risk, what you could do is say to them, we could either discipline you now, we put you through a disciplinary process now, or we'll suspend you without pay for the quarantine period. Which would you prefer? And that way get the agreement of the employee. So I've answered my own question there. That's how I'd probably approach it if I were the employer.
Thank you, Michael, for that. Turning to lockdown on the other side, we're still hearing from clients whose staff are shielding, but not necessarily because they're clinically vulnerable. They're just simply nervous about coming back to work, which is understandable in the circumstances in lots of ways. In that situation, is it open to employers to simply leave the staff on furlough?
Yes, if the rules on who can be furloughed in that sense haven't changed since they were, well, I won't say when they were first published because the guidance changed every few days when it was first published, but the settled position on the government guidance is that if you are caring for someone who's shielding or you're shielding yourself, then you can be furloughed. And that would still be the case now. I think the issues that are going to arise now are all to do with employers wanting employees to come back. The issues, when they first came up, those issues about who can be furloughed are all to do with the employer making sure that they were not going to breach the rules for claiming the furlough grant. So they just wanted to make sure they were claiming for the right people for the right periods. What's going to happen now is hundreds of thousands, if not millions, of individual situations where an employee has got personal circumstances that the employer is going to have to consider. Many employees will have very straightforward circumstances. They'll want to come back. But there'll be a number of employees, a high number, who will be concerned for some reason or other. And you have to bear in mind that furloughing an employee is a decision for the employer. So the employee doesn't have a right to be furloughed because they're worried, or if they're caring, or if they're shielding themselves. The employer shouldn't want to have anyone who is shielding, but if the employer feels that the employee in some way is not being sincere or straightforward about things, the employer doesn't have to furlough them. The employer can ask them to come in. I think in many workplaces, the sort of conflict that I can see coming will be avoided because employers won't want a large proportion of their employees to come back onto their sites, into the workplace straight away. And so what ought to be possible for most employers of any size will be that the willing returners will come back without a problem, and that will be enough to populate workplaces as far as employers want them to be populated at the moment, and that the difficult cases will take a little bit longer. But if things go well for employers, the two processes will match up in time terms, so that by the time the employer needs the vast majority of people in and can have them safely in, all those individual issues will have been ironed out. It won't be like that because human nature isn't like that. So there will be difficult, intractable problems, but I'm hoping from an employer's point of view that most can be negotiated peacefully.
Thank you, Michael. So again, a practical, pragmatic approach to be worked through between employer and employee. So a further question around lockdown. Um, we obviously now have different lockdown rules in different parts of the union. So England compared to Wales is different, and England compared to Scotland is different. And the government's made it clear that we could have regional lockdowns going forward with different restrictions. How do employers and employees fare when they've got different travel restrictions in their place of home and their place of work? So at the moment, of course, the classic example would be employee lives in Wales and travel's prohibited, but they work in England. So how do they get from Wales to England? And how would that work if they closed down a particular town and the employee lived there, but their place of work wasn't in lockdown?
Yeah. Part of me wants to try and solve that problem practically, as if I were Boris Johnson, but I'm not going to do that. The fact is that there'll be situations sometimes that cannot be resolved. That, you know, if the resolution is, the desired resolution is the employee to come into work and do their job, that's the normal, that's what everyone is paid to do. If that can't happen because someone is trapped in the wrong country, just as it would have been a few months ago if they were trapped in France or Italy or somewhere else like that, practically speaking, the employer can't magic them over the border and make them work. The employer is going to have to look for some practical and, again, pragmatic solutions to try and get some work out of that employee from home if it's possible. If it's not possible, then the employee is effectively prevented from working, and the employer then has to work out what can they do in those circumstances. How should they react? The employee in that case won't be guilty of misconduct in the sense that they won't be willfully failing to come to work, but they will be unable to come to work. It's as if they are sick, but they're not. And the employer has to, as ever, not jump to any rash decisions about what to do with that employee, because the employee, in most cases, will be blameless. If the employer can't find any solutions, they can't, and say they can't furlough them. At the moment, they could do. If they're furloughed by the 10th of June and they've been furloughed for 3 weeks by the beginning of July, they'll be able to furlough them. But if that's not a possibility and they've just got someone sitting at home unable to do anything, the employer's got to find a way forward, and they could treat them as sick. They could agree some form of half pay, lower pay with them. They'd have to agree it. It would be harsh of an employer in that situation, I think, to treat it as a capability issue. I mean, one could, if the employer dismissed the employee after a bit of a discussion and a few meetings by Skype or Zoom or whatever, and dismissed them because they were not able to come to work, then that could work. But I think a tribunal would look for ways of tripping that employer up, because I don't think they'd like them very much. But that might have to happen. I mean, if you change the facts and just say that Wales is going to be locked down for 2 years, and someone works in England and lives in Wales and just cannot get to work, that employee's work is going to finish unless they can work at home. So you only have to ramp up the facts a little bit to test out the theory. And really the end result is, if you can't come to work long term and you can't work from home, your employment is eventually going to come to an end.
Okay.
So in the fairest possible way.
So more examples of practical approaches needed to be taken by employers, which of course is very difficult for people to gauge on an individual case-by-case basis. A very practical issue now, which lots of people around the country are thinking about at the moment, and that of course is holiday plans. And as they stand at the moment, the government is saying that anybody who goes on holiday abroad has to come back and self-quarantine for 14 days. Lots of questions around that. But the main one is, how does the 14-day quarantine period get dealt with? Does the employee have to take that as holiday? Can they take that as unpaid holiday? Or can they simply say to their employer that they intend to work from home for 14 days?
Well, I think that if I were the employer in that situation and someone took a week off and I didn't know where they were going, they were just going to take a week off, and they were able at that stage to fly out and then fly back into the country so that they needed 14 days quarantine when they came back, I would be fed up as the employer if I didn't know what was going on, because my employee would have at least risked not being able to work for 2 weeks after they came back from their lucky old holiday overseas. Now, it's always possible for employers to agree leave of absence, extended holidays. Every employer will have their own rules about how much holiday you can take at a time. So, for example, if the employee could not work at home and was just going to be stuck for 14 days doing nothing away from the workplace, if they had, I think if they didn't tell the employer what was going on beforehand, I'd be tempted as an employer to treat that as an issue of misconduct. And I would be itching not to pay them for the 14 days in that particular scenario. If they had talked to me about it before, I would try and agree something with them. I might try and talk them out of it if they couldn't work during a quarantine period. If they could work during the quarantine, might be no problem. You know, it's I think if it was discussed in advance and agreed, there's never an issue. But I think in the end, the employer has got to put the risk on the employee there. So if you, as an employee, want to go on a holiday in that way and take a chance of becoming unwell, certainly having to be away for 2 weeks when you flew back in, if things went wrong for you, an employer wouldn't have much sympathy. It would be as if you've just, put yourself in danger unnecessarily. You decided to go in for the World Speedway Championships and broken a leg. I mean, the employer in that situation would be thinking, why did you do that? Why have you put yourself in that situation where you can't work for 3 weeks? As I say, if they hadn't told them in advance where they were going, as the employer, I'd be thinking disciplinary if they couldn't come to work. If it's discussed in advance, as ever, with all these things, fine. If it's agreed, no problem. In some ways, it might suit an employer. Everyone is racking up holiday entitlement they haven't taken over the last few months. Everyone will be different, but there'll be plenty of people who haven't been able to take holiday. So if an employer had it put to them that an employee wanted to fly out for a week and was actually going to be away for 3 weeks and would like to treat that as holiday and the employer's happy, terrific. You crossed off 3 weeks holiday if it's done by agreement.
Okay, thank you for that, Michael. That's very helpful. I think all those answers there indicate one thing, and that is the importance of employers having conversations with their employees, and probably, if in doubt, speaking to their solicitors as well and taking appropriate advice in the background behind those conversations. So thank you. So moving on then now to our last group of questions. There's lots of discussion, obviously, in the media about the inevitability of redundancies and job losses coming out of the current situation, which is obviously tragic for everybody affected. First question is, can people use the furlough scheme as part of their notice period?
I don't think there's any problem with doing that in principle. I've seen nothing in the guidance that's been published so far that prevents employers using furlough pay as part of or all of notice pay if they don't get into trouble in another direction. So in principle, the furlough grant can be applied to pay notice pay. I think that's true. Redundancy pay, statutory redundancy pay, I can't see a way that an employer can possibly claim that from the government, and that's clear. The issue is more to do with how much do you pay someone during their notice period. So, for example, if you furloughed an employee and they're on 80% or 2,500 tops per month, as the current rules set out, there are arguments that if you give someone notice, there are situations where they're entitled to their full pay during the notice period. So if you've been furloughing at less than full pay, there might be circumstances, and may well be, where you have to up their pay for what will be the notice period, depending on what you'd agreed. There's another point that arises for me, which is how on what terms did the employer put someone on furlough? Because when everything was being done in a rush 10, 11 weeks ago, and people were they were racing their employees to the door effectively and agreeing anything that could be agreed so as not to be in breach of contract, it may well be the case that if the employer says, well, now we furlough you, but now we need to make you redundant, so we're going to pay you this money, the employer might say, well, I only agreed to being paid 80% of my money, or £2,500 maximum each month, because you weren't going to make me redundant. Because when you put me on furlough, when you made me that offer to furlough me on less pay, you said it was to avoid redundancies. So now you are making me redundant. I think my agreement to 80% or 2,500, that's gone. Now, what employers are going to have to do there is look back at what they got, what evidence have they got of the agreement they made 10, 11 weeks ago about what they would pay. I think a tribunal would be quite sympathetic to an employee who was arguing that they should have all of their pay during their notice period, because it was implied that they weren't going to be made redundant because they were going to be furloughed on less pay instead.
Okay, thank you, Michael. So you touched there on redundancy and principles that employers will be looking at for redundancies. Lots of very specific questions around redundancies. But for the benefit of people watching, what advice would you give people about selection criteria for redundancies and how to manage that selection criteria? I was looking for some general guidance for people rather than any specifics for particular circumstances.
Yeah. Think about it carefully, generally. Don't make your personal decisions about the people who are going to be made redundant first and then work out how to get there. Don't do that. That's never a good look in a tribunal claim. Work out your pools for selection. Split it up so you can see how many fitters do I need, how many drivers do I need. Break it down into smaller problems. When you come to having to select people for redundancy, it is possible to start with the short-serving employees if you want to. If you've got people who have been there less than 2 years, you can choose them, and it's respectable to do that if it suits the employee. You don't have to, but that can reduce the numbers of potential tribunal claimants, because you can't claim unfair dismissal unless you've had 2 years service. Once you're into selection, once you're into actually choosing between employees in a pool for selection, it's best to try and use objective criteria, measurable criteria rather than subjective. You can have a mixture, that's okay. You've got to balance them out. So performance can be measurable, or it can be a perception of the manager. Attitude, very subjective. Attendance, timekeeping, misconduct, those are objective. For attendance, you'd have to take into account disability discrimination issues. If someone's disabled, they may not have attended work so regularly. So there are some measures that are very straightforward and others that are more subjective. And the more subjective criteria you have, the more challenge you're likely to face later on. Just work out what you need for your business. Work out what people you need to end up with. I don't mean personally, what type of person you need to have after this is all over, and then sort out your criteria so they match that. So you produce the machine that gives you the right employees without having to fix it. And if you do that and you go through the normal consultation procedures with the employees, you should be safe from any tribunal claim.
Thank you, Michael. So the overarching advice is think of your strategy for where you want to get to, and then work out how to actually follow that path on a practical basis.
Exactly.
Thank you, Michael. Thank you very much for your time today. That concludes all our questions from our clients. Thank you very much for your time.
No problem at all. Thank you.